Today, wish to announce an important decision by the government in relation to the Civil Partnerships Act. Contrary to what some of you may have expected, the Act will not be repealed, but let me explain. Cabinet has, since the time of the election, obviously been conscious about a range of other important things that were in our 100-day plan, and we've not had time until now to consider this matter. And I note that it wasn't something we ever put up as a high priority to deal with, but nevertheless today we have considered a paper from the Attorney-General, and there was a lengthy discussion in Cabinet about what the way forward should be. Let me explain though firstly the legal background for people. Let's remember that across Australia now, couples, whether they be same-sex couples or men and women living together for 2 years or more, do have legal rights under the common law as de factos. So that was there right now. What the current Civil Partnerships Act actually does is provide, if you like, certification, legal certification of an arrangement, which allows certain, let's say, streamlining in terms of administrative matters when people, same-sex couples or indeed men and women who are registered when applying for entitlements with government. So what we've then been looking at is what is occurring interstate, where we have New South Wales and Tasmania in particular that have partnerships registers and the like, and these matters have been debated. We've also looked at what people have been saying to us since the election and prior to the election. Obviously the gay and lesbian community have got a point, and there are many people in Christian churches who have also spoken to us. So this is the decision. The current Act will be retained. Okay, the Act will be retained, but it will be amended. The thing that has, if you like, offended Christian groups is that the current provisions in the Act, particularly Section 11, seek to emulate marriage. Now, there were two ways that people could go about registering a civil partnership. They could simply fill out the forms, submit them, there was a cooling off period, and a partnership could be registered. Alternatively, under Section 11, there was another pathway, if I can put it that way, where there was a state-sanctioned, voluntary, I must stress, a state-sanctioned ceremony. So that, if you like, is the bit that for people in Christian churches has been, if you like, unacceptable to them because it sought to emulate marriage. So the decision of Cabinet is essentially to bring amendments to the Parliament, minimal amendments that will keep, if you like, the legal rights of people who've already registered civil partnerships, but provide for no state-sanctioned ceremony. That, of course, does not preclude people from having their own ceremony, a matter for them privately to do whatever they want. So I might just hand to the Attorney to further flesh this out. Yeah.
Thank you, Premier. So, folks, what we have is a situation in Queensland where the Premier indicated currently under the legislation people can apply through the births, deaths and marriages for a registration of their partnership, or secondly they can choose or tick a box for a declaration, which is essentially the part that mimics marriage. So under the changes that the government have decided today is that the first part will be retained, i.e. people will be able to register their civil partnerships through the births, deaths and marriages, and we do that for fundamental legal reasons. I was conscious when the government won the election, and the Premier and my comments have been consistent that we did not want to leave people in any legal limbo. Now, the legal limbo that you potentially can drag people into is that if they've had their relationships registered for whatever reason, but if you look at the legal reasons for relationship registration, for instance the Succession Act, where one wants to leave items in a will to their partner, it authorises that to take place. There was a strong argument in the community that people, for next of kin reasons and for hospital reasons, they needed to prove that relationship. So it wasn't that the relationship didn't exist prior to that or under the de facto relationship. The difference is, under the de facto, you have to prove the relationship. By having the registration enables the people to prove that relationship with a lot less bureaucracy and red tape. So I think what we've achieved now is those that have committed civil partnerships already, and out of 609 609 registrations, only 21 proceeded to ceremonies. 158 of that 609 were in fact not same-sex couples, but heterosexual partners. So what we've done is, by retaining the elements in the legislation that allows for the registration, we are certainly not leaving anyone in any legal implications in the future.